All right, welcome everyone to the next session. This is organized by the Bar Council Risk Management Committee, titled MyBar Risk Management Podcast, Risk Manage and Elevate Your Practice. So this session, the host of our podcast today will be Mr. Mohan, member of the Risk Management Committee, as well as with us is our panel solicitor, Mr. Mr. Lam. Sorry. Okay, so with no further ado, please feel free to start. Thank you.
A very good afternoon to all and welcome to my bar risk management podcast series. My name is Mohan Sankaran and I'm a member of the risk management committee and the moderator for the podcast today. In today's topic, risk manage, elevate your practice. I'm going to ask our panel member how we can navigate the crucial intersection of legal practice and proactive risk management. As we all know, legal practice in Malaysia is a very highly regulated profession. For every advocate and solicitors in Malaysia, the pursuit of justice is often accompanied by risk. Let it be the advice or the legal opinion we give to our client, the correspondences we send, the files we store, the type of clients we onboard. So learning to navigate it's about finding the balance between protecting ourselves and serving our client with confidence, which ultimately transform into stronger public trust in the legal profession. So despite the bar relentless efforts to remind and alert members of the dangers, many still fall for it, and as a result, the number of cases of negligence reported to the scheme remains high. But what if we could shift our perspective? What if we see risk management not as a burdensome compliance exercise, but as a tool to protect our firms, protect our reputation, enhance our services, elevate our practice, and ultimately save us from being sued? Uh, this is exactly what the aim of this podcast is. And to help us unpack this, I'm truly pleased to welcome a, a foremost expert in the field of professional indemnity and legal ethics, Mr. C.S. Lam, a senior lawyer and a panel solicitor under the Malaysian Bar PIS scheme. Thank you for joining us today, Mr. Lam.
Thank you for having me, Mohan.
Okay, Mr. Lam, I'm going to go straight to the questions. Uh, as a panel solicitor for the PIS scheme, you have seen firsthand the claims that comes in. So based on your experience, what is the most common recurring scenario that leads to a negligence claim against a solicitor?
Thank you, Mohan. There's a very relevant questions. In terms of practice, Mohan, I reckon that there are many lawyers, whether fresh lawyers or maybe or senior lawyers, most of them decide to take brief or new case based on commercial decision. I would say commercial decision is rather than legal decision is because most lawyers tend to appease the client's needs. Meaning to say, in the context of commercial, lawyers tend to always sandwich themselves as a common lawyer. Meaning to say, for example, in a sale and purchase agreement, one lawyer tend to act for both parties, and they always sandwich in between when legal issues crops up. Okay. Another example is landlord and tenant situation, where many lawyers tend to work together with real estate agents, and they like to put themselves in a common position and act for both parties with the very good intention. Okay, that is to either save costs, um, easy to maneuver to make the conclusion of the deal, likely to get the sale done. That is if everything runs smooth. However, if things get ugly, then this common lawyer, this lawyer will have some issues to face. And that is where is this so-called problem comes our under the PII scheme. Yeah. So before I end here, one of the issue is if the tenant, if you're acting for landlord as well as tenant, if tenant say when can I get back my deposit and all that, or when can I get the vacant possession, and you also acting for the landlord, you will land up yourself in a sandwich situation. Who should you act and advise? Are you going to advise the landlord? At the same time, are you going to protect the tenant's interests? But you are sandwiched in between. So that is where when things turns ugly, this lawyer will have all these issues. That's how my first take is that always try not to land up yourself as a common lawyer position. No harm telling one party, you decide who you're supposed to act for. If you are more comfortable with tenant, for example, then you inform the landlord, I can't act for you. Okay, can you just maybe introduce another lawyer or advise the landlord to get another lawyer so that each will cover and protect respective clients. That would be a better position, in my opinion.
So, Mr. Lam, earlier, as you started, you said it's a commercial decision. So, when it comes to commercial decision, that means lawyers also plays a role of how, clients management comes into practice. So, many claims that part of the negligence claim starts with the breakdown of the solicitors and client relationship. Like in your case earlier, you have said about the tenant, a lawyer acting for both parties. So in terms of when there is a dispute, where is his role, position will be. So what was the mistake that lead, from your experience, what does managing clients' expectation actually look like in practice, especially when cases starts to go sideways?
Yeah, I think from PII, our as a panel solicitor perspective, we tend to look at that's my practice. Tend to look at the principles and the law of the highest authority. And there's like you said, client solicitors relationship. One of the federal court decisions says client solicitor relationship can be formed either impliedly or and express. The word is and expressly, so it's not all. So how do you come into this position, imply um, uh, relationship and express relationship? Of course, express relationship is where you get warrant to act. You ask client to sign a warrant to act, and then you inform the client the scope of work that the authority or instructions you give me. But implied appointment is totally absence of something in writing. There's nothing in writing. So in federal court decision, it says that once a lawyer assume responsibility, assume meaning even by words or by conduct, you assume that role, and then you give some legal advice, you are caught in this implied appointment, and that's where client solicitor relationship could be said to have formed in that instance. So, in my opinion, if you are caught, the word is commercial. If you are invited to say, for example, a board meetings, for example, board meetings, you have directors, you have shareholders, so you have to make clear your position. Are you going to to be the lawyer for the board or the directors individual or the shareholders. See, so there are, in one meeting, you may come to or entail or face with 3 different entities. That is as far as legal issue is concerned. So commercially, you don't care. Commercially, you think this is a normal meeting. Okay, so you just attend the meeting and you may choose to be quiet, remain quiet, where there is some proposal between shareholders, directors, and even company secretary may be attending that. But you choose to remain silent. So you may land up that this client solicitor relationship may come into the formation there. You see, so commercially means as a practicing lawyer, you must be very clear. Are you in that commercial decision, or you want to make clear to all the parties attending what is your legal position? That is how I see. From my earlier practice, one of my former bosses always said, you run your law firm to not run commercially."
Yeah, that's true.
Yeah.
Because
So,
again, this is a challenge for the sole proprietors and the small firms.
yes, I agree with
Because
you, Mohan.
this is one aspect where the survival of the firm and the pursuit of
Yeah.
justice, the balance that they have to play,
Yes.
and the making sure that they have enough sufficient fund for
Mm,
them to
mm,
this thing.
mm.
So that brings me to my next question, which is the statistics that we get from Bar Council shows majority of the negligence suit originate from the conveyancing and civil litigation
Yeah,
practice.
I agree.
Could you walk us through some case studies on both these areas?
Yeah.
What was the mistake that led to the claim, and what are the precautionary steps that we could have completely could have taken to completely prevent it?
Yes. Yeah. Like I said, the main um, issue is, of course, through through the lawyer's experience. Never put yourself in a sandwich position. Always make clear your legal position when you come to facing clients. I use the word don't sapu everything. Yeah. So as a lawyer, you don't sapu, meaning you don't grab everything before you make clear your legal position. Okay. I know, survivor, you need to run your law firm at the same time. You need to make clear your legal position. But that is one of the pitfalls that many young lawyers or sole proprietor or a medium-sized law firm, that they tend to attend some clients and they tend to sapu everything first, then they'll deal with it later on. That is the beginning of the disaster, in my opinion, in my experience. Another pitfall is stakeholder position. Many small size or medium size law firms, they tend to have this stakeholder issues in terms of clients account and office accounts issues. These are the 2 very common area where many small size practicing law firms are facing. Okay, we don't talk about the dispute between partners. We talk about how you manage the money that is deposited into your client's account. That is a big chunk of legal issues that always trigger our PII scheme. That's why I believe in our PII committee, like you are running. You all have done many awareness campaign like today. Another way is to hold more interaction sessions like now with practicing lawyers, and magazine like Jurist and all this Elevate circular, I believe is another ways to disseminate all this awareness about the importance of lawyers managing stakeholder or managing their position as a stakeholder. We don't talk about money. We talk about your position as a stakeholder first. Where do you stand as a stakeholder? Some lawyers do not even know the meaning or definition of stakeholder. Why? Because most lawyers that come into under PII, they always thought, whether it's in good faith or bad faith, they always thought the money that comes into my law office account is my money. And that is a wrong concept. Okay. And in legal practice, we have this very important terms, which is called stakeholder, which in practice is the main this beginning of the disaster if you do not, how should I say, actually understand the meaning of these stakeholders as a stakeholder's duty.
I think the Bar Council, to be fair, I think they have done a lot on
I
the
agree.
risk management
Yeah.
side. And recently, we have also launched the Elevate, whereby you have all materials that a young lawyer who probably just been called to the bar and decided to open up his own or her own firm has all the checklist that will help them in their daily work. For example, if they are faced with some kind of stakeholder, like what you're saying, we have a checklist for how to for you to watch out
Yeah.
for this. And
Yeah.
then if you are acting for a convincing file, so we have all that. And also I think the risk management committee will send out alerts when we see a trend happening in the scheme. For example, if we see a pattern, so we will then send out alerts to members so that they will be aware and will take precautions. So these are efforts taken by the Bar Council and through the RM committee and Elevate committee. And we have also put this up in the website. So coming back to this other issues, what do you think about the role of AI in
Yeah,
the
that's a very interesting
because
issues. Yeah.
I believe that those days, if you're talking about practice in the past, uh, clients are not well informed. But
Yeah.
recently, when
Yeah.
the demographic of the clients have changed, a
Yeah.
lot of them are
Very knowledgeable now.
very knowledgeable,
Yeah.
and they are
Well
very
informed.
IT
Yeah.
savvy and all
Yeah.
these things.
Yeah.
So everything they will go and check before they come to you.
Yes.
So how do you see this as a problem?
I see that there's the need of lawyers to explore this AI this advancement of the technology. But there's also always pitfalls or worries that this AI may tend to make lawyers becoming a bit lazy. We have Singapore cases where reported cases where some lawyers, or even Australia, some lawyers very rely on the AI's legal search on the AI, and it turns out that some of the information or cases cited before the court are not actually reported at all. There's one downside. Another one in terms of practice, which I actually am facing also, is about imposter. There are many physical person that approach lawyers as an imposter. Some inexperienced lawyer, especially in conveyancing, they take the physical person, despite being stranger, as a real person. But later, if things turn ugly, it turns out that that person that this lawyer claim is a client, but it turns out it's not the client, it's an imposter, it's a fake person.
Yeah.
Yeah. So AI may come into play if, for example, facial recognition. Okay. Maybe my law firm one day I will I will get a facial recognition with
Yeah.
your IC, and then I
We will
will
be able to trace
confirm whether you are the real person.
imposters.
Yeah.
I think the other issues is also when you talk about imposters is also people who tend to represent themselves as lawyers.
Yes.
Because they go and refer from Chat GPT and all that, so
Yes.
they know how to answer your questions.
Correct.
And that is where public needs to be aware that they need to go back to the Bar Council website to check whether this particular person that they are dealing with,
In the list, yeah.
it's actually a qualified lawyer and
Yeah.
they are in the list
Yeah.
of
Yes.
qualified lawyers.
Yes.
So that is also something that public needs to be aware of.
Yeah.
So one more thing that I would like to ask you as a panel solicitor. Let's say there are lawyers here or outside there who feels that they might be subject to a claim. So what are the steps that they need to take from your perspective as a panel solicitor? What are the things that they should be aware of?
Yeah, I always facing this inquiries. The first thing I always suggest to these lawyers is number one, please call our bar council, maybe the subcommittee like RM or the law claims. I believe they will be able to advise, give a proper advice before the next step is to be taken. Of course, as a panel solicitor, we without instructions, proper instruction. When I say proper instruction, I mean as a panel solicitor, we have two instructions to be taken. Number one is our bar insurers. Number two is the potential insured party, which will be will come into or will come on board after the insurers give us the instructions. So before this potential insured party become my client, I would first check, tell them that they should go to either law claims or to your department, RM department, or any bar council subcommittee to make inquiries as to what should we do, because under the PI we have about, I think we have 60 days for
So
the potential to
that is
lodge a
under the
notification or
clause
something.
12 of the this thing that the moment you get LOD or
you feel
you
something,
you feel something is
your
going to come
sandwich in between,
like what you said.
yeah.
So the moment you feel you have that feeling, it is always advisable for you to notify the insurers early.
I would suggest so.
Yeah.
Yeah, I would suggest so.
And not to wait up to the very last minute.
Yes, I have encountered one lawyer, insured party that she didn't know what to do. So after 6 months only, she decided to contact law claims or bar council. The matter has already been overwhelmed. It's difficult to reverse the situation.
Undo
yeah. So, but that does not mean it's the end of the thing.
Yeah.
Because I always say that the worst scenario in terms of negligence is for the insurers to come in and for panel solicitors to come in, so-called rescue you, to rescue the party out of the woods. It's not life and death situation. It's not like you're going to be sentenced you to death or something like that. So even though 60 days may have lapsed, always contact bar council. I believe they are able to assist, perhaps make suggestion how this insured person to help them to maneuver how to get into this protection, or how to get panel solicitor to come in and things like that. So
Yeah. I think,
never abandon bar council, in my opinion.
no, I think
Make
some of
full
them,
use of bar council. Like
of-
your unit RM. Make full use of it.
yes,
So I say,
in terms of that, RM is doing our best to do roadshows and all that to tell them that what is covered, what is not covered. Even we do programs for the ethics students who have just completed their ethic lectures. We give them an RM talk just to give them some kind of awareness on what are the things that they should do or watch out these are
Sorry
the
to interject, not only awareness, I think
Yeah.
more interactions, like dialogue like this, more dialogues
Mm.
between the Bar Council committee members, senior lawyers, maybe retired judges, to have a dialogue session with all the lawyers, not just theory side.
Yeah, I think
That's
we
my
will
opinion.
we will take that on board and perhaps suggest to the committee. So, Mr. Lam, just we have about 2.5 minutes
Okay.
to close. Mr. Lam, after handling all these cases, what is your one golden rule, the single most important piece of advice? So, to like a takeaway of this session.
Yeah, I would say that the word elevate we use elevate is very much related to standard or practice. My opinion after all this experience as a panel, I believe the entire bar council and all of us legal practitioners should go for how we going to upgrade the standard of practice, which would justify the word elevate. Elevate, not just elevate your pocket, your reputation, but elevate the standard of practice is
Yeah.
also very important in my opinion. So that's how I see it. As a panel solicitor, we always argue before the judges. Of course, we have different courts. For me, on my part, I always argue that we need to set one standard, just like how Bar Council set the checklist for convincing lawyers to refer to. But in litigation, for example, either in arbitration or whatever, in litigation, we don't have a checklist. We do not have one standard of practice that litigation lawyer can refer to. Okay, one ruler does not fit all.
Yeah.
So we need to have one ruler, lah. So because we are professionals, so sometimes a claimant may not be a lawyers, but they can just simply make allegation against a professional. So in my opinion, this standard of practice, we need to get one checklist how, as far as litigation is concerned, how to upgrade, maintain a high standard in that context. That's how I see it.
Yeah, I think this is something that, in the past years, I think a lot of cases been reported against lawyers, and this somehow gives some kind of a negative connotation on our profession as well. So that is the reason why we are emphasizing on all these trainings and dialogue sessions like this, and also publications like Juris, for us to try to, like what you said, elevate ourselves. Then indirectly we will elevate the professions to the next level. Thank you very much, Mr. Lam, for sharing your
Thank you very much.
experiences
Thank you for having me.
and coming all the way this Sunday.
No problem.
Thank you, and thank you all for
Thank you.
listening.
Thank you very much.